we acknowledge we live on the traditional land of the, whoa,
The volume needs to be adjusted.
okay. Yeah, talk to the man, yeah. We acknowledge we live on the traditional land of the Kalapuya people, whose descendants are citizens of the Confederated Tribes of the Grand Ronde Community of Oregon and the Confederated Tribes of the Siletz Indians of Oregon. We honor the land and the people who have cared for it and reaffirm our commitment to steward and honor the land through our work. Rather than the usual slide presentation, check the page at your seat. Unlike slides, you can take it with you later. It's the page with Representative Fazio's portrait on it. He is our next October guest for League Speaker Series. After Professor Epps' presentation, we'll ask that you legibly write your questions on the cards at your table, and then I'll read them and deliver them to Mr. Epps. Next, I have the great honor. Is it me? Okay, good. I have the great honor to introduce Professor Garrett Epps, who is an American legal scholar, novelist, and journalist. He was a professor of law at the University of Baltimore until his retirement in June 2020. Previously, he was the Orlando J. and Marion H. Collis Professor of Law at the University of Oregon. Now, back at the U of O, is Professor of Practice. Many of you know him or know of him. I first heard him on NPR's Diane Reeves show, reporting on the U.S. Supreme Court. Epps appeared as a constitutional authority on the 2021 Netflix production of Amend, The Fight for America, which is a documentary series producing and starring Will Smith, and a lot of other famous people. It covers the legacy of the 14th Amendment. I highly recommend to you that you view this educational and mostly entertaining as well series. Epps attended Harvard College, where he was president of the Harvard Crimson. He later received an MA degree in creative writing from Hollins University and a JD degree from Duke University, where he was first in his class. I hope your mother was really, really proud of you. He worked as an editor, reporter, or writer for the Richmond Afro-American, the Virginia Churchman, the Freelance Star, the Washington Post, New York Times, the Atlantic, and currently the Washington Monthly. Epps has written 2 novels and several other nonfiction books and garnered many awards for them. He spent a year clerking for Judge John D. Butzner of the United States Court of Appeals for the Fourth Circuit. Other than that, he's pretty much a slider. In his article, The Founder's Great Mistake, he urged America to amend its constitution to more closely resemble a parliamentary system. Quite a provocative idea. There's much more to say about Professor Epps' extraordinary career, but I'll stop here and you can Google him yourself. Professor, you're up.
Thank you for that generous introduction, and particularly for invoking the spirit of my mother, brooding over so many things. My mother, he said, I hope your mother was proud. I don't know for sure. I do know that a friend of mine once asked her, someone I later met, asked her, are you related to Garrett Epps? And she said, at times, he is my son. I hope this is one of those times. I'm always delighted to be in front of the League of Women Voters, the Lane County audience. And it always reminds me that when I started many years ago as a political reporter before I went to law school, the late Charlie McDowell, very famous political journalist, gave me some advice, 3 or 4 points. And one of them was, always do whatever the league asks. And of course, this chapter is very special to me. I lived in Eugene for 16 years before moving back to the East Coast, and my old friend Becky Gladstone and I collaborated on various things. And two very dear friends of mine, very active here in the audience, Jack and Ellen Maddox. Jack, among other things, kept me out of trouble when I wrote my one-volume history, Democracy Reborn, and would give me back my manuscript was written in the margin. This will make you look like an idiot. So that is really the best kind of editorial advice to get. I can look like an idiot without assistance, but Jack will do some of that. I will warn you now that asking me to talk about what's going on with the current Supreme Court is a little bit like asking Captain Ahab to give a talk on whales I have known. I will try not to overshoot the time mark, because I think that your questions are probably as important as my insights. If I get too much over 30 minutes, because I just lose it like Dr. Strangelove, could someone just flag, because I've got so much to say that I'll always be stopping in the middle, no matter where I stop. So with that said, let's start. This coming February, the United States Supreme Court will celebrate its 233rd birthday. Twice before, over that rough quarter millennium, the Supreme Court has come unmoored from its place in our system of government and precipitated a national crisis by attempting to move from the edge to the center of power and govern the country with its judicial authority. The first such crisis arose during the 1850s, when a court dominated by slave owners and slave interests decided to solve the slavery controversy by awarding total permanent victory to the South. The second took place during the 1930s, when a majority of the 9 old men determined to uproot any glimmer of progressive government, labor rights, or economic justice. Depression began. In both cases, the court's motive was the same. It sought to return America to the grandeur of an imagined past. In the Dred Scott case, this golden era was a paradise when white men were not questioned. For the New Deal court, it was the brutal grandeur of the Gilded Age, where property and massed wealth were the only values enshrined in the Constitution. We are in the third great crisis of the Supreme Court's history. And in this case, the court's motive is the same. The court's aggressive behavior over the last 2 years flows from a very deep well of conservative grievance and resentment at the social changes of the last 50 years, at the very idea that America should be a multicultural republic, of the changes in the status of women and the liberty afforded to human sexuality, and of any challenge to the cultural dominance of a peculiar white American strain of conservative Christianity. Whatever Donald Trump's own future may be, he is with us in a Supreme Court determined to make America great again. And just as in the 1850s and 1930s, we are in a dangerous crisis. It threatens generations of progress we have made in our lifetimes for genuine democracy. One of the things Americans like to believe and are taught more or less implicitly in school is that we are an exception, American exceptionalism. We are an exception to the somber lessons of history. Somewhere above us are the better angels of our nature, who always ensure that no matter how dark the night may be, the Republic will face a new dawn of triumph. I regret to say that this is a fantasy. It's as dangerous in its way as the conservative dream world the court is seeking to restore. We will never escape the current dangerous moment unless we face the facts. Now, I can only give you, I have spent the last summer amassing the chronology of the process I'm going to describe briefly, and I can't go through everything I came up with, but I can summarize briefly what I think has happened and point out that chronology on some occasions tells us more. You know, I as a reporter for the Washington Post, I learned from the investigative unit, they said, sometimes the order things happen in is more important than what they are. And I have been putting together a chronology of the past 7 years. If anyone looking at the Supreme Court today sees an entirely different institution than the court that began New Year's 2016. Most obviously, the turnover of personnel, 4 new justices in 7 years. That is the most rapid turnover since Franklin Roosevelt's 3rd term. He got to replace most of the justices. The court has also dramatically changed how it exercises its jurisdiction and the procedures it uses to decide important cases, with the rise of what is called the emergency or shadow docket, which I'm sure you've seen referred to in news reports, but for non-lawyers may not appreciate how important and radical this change is. The shadow docket has always existed, largely for things that literally must be decided by midnight on a given day. Death penalty appeals, for example, are heard as emergency motions without oral argument, without full briefing, and so forth. This court has begun to use the shadow docket to decide important cases without allowing full briefing, without hearing oral argument, without permitting amicus briefing or participation by the public, and often without either giving warning or explaining its decisions, which will consist of one line. You know, the application for the stay is granted. Sometimes they do not even indicate which justices voted which way. And we have to glean that from dissents that are filed sometimes by the justices who disagree with the decision. These are very important cases being decided: religious freedom cases, public health cases, election law cases, and there is no record, no fingerprint, no explanation to the public of why the court is stepping in. During the Trump years, the court used the shadow docket aggressively to make sure that lower courts did not obstruct Trump policies, such as the building of the border wall. Strangely enough, with the change of administration, the shadow docket is now being used to block administration policies by a bizarre coincidence. More important, of course, is the court's new jurisprudence. And I will briefly touch on it, but I think we'll probably want to talk more about it in the questions. We can see how this court operates. The first thing I want to say, and I say this to my constitutional law students, I taught Constitutional Law 1 in the spring semester at the UO this year. And I got an email from a student in the middle of the summer who said, and it's very nice, heading the subject line, "I enjoyed your course." And when I opened the email, I said, "But what the hell good did it do?" And the answer is none, because this is year 0 for constitutional doctrine in the 21st century. The court has, in essence, called off all existing precedents and said everything is up for grabs. And The first results of this change are startling indeed. A complete rollback of the constitutional right to abortion, sweeping expansion of Second Amendment gun rights, the cutback in the government's power to address the climate crisis, a radical demolition of the wall between church and state. Equally startling is the court's new method of reaching decisions. Precedent no longer matters. The justices have said, if 5 members of the current court consider a precedent egregiously wrong. I'm not sure what work egregiously does in that sentence, but it's kind of like, we really, really want it, right? We want to overturn it. That egregiously wrong category, the majority has hinted, the new majority has hinted, includes most of the individual rights decisions of the past 50 years, particularly those pertaining to sexuality, LGBT rights, and to some extent, First Amendment freedom of speech. What has happened? Well, and this is what I spent the summer trying to create a chronology for. The change in the court and the change in the federal courts generally is the result of a sustained, highly organized, well-funded, entirely conscious campaign to annex the federal judiciary to the political party system. And we can look at the record and you can point to places where, one side or another has done something that seems to violate the traditional norms of respect for courts. But it would be a mistake to say that this is being done by both sides. This campaign was organized, initiated and conducted by the Republican Party, the conservative legal movement, and its billionaire backers, and the politicized wing of white evangelical Christian churches. Democrats and progressives have responded spasmodically, clumsily, and to very little effect, but it is certainly undeniable that they too have made statements and taken actions that violate traditional ideas of respect for judicial independence. That response is not only appropriate, but necessary. The old rules about judicial independence will never be restored. We are in a new world, and a norm that only binds one side of a political dispute is not a norm. It is a trap. Political fights over the court and over the lower courts are part of a struggle over this court as it is, not as it once was. And what it is today is a partisan body that must live by partisan rules. The story begins in February 2016 when Justice Scalia died suddenly. Scalia was 80 years old. Anyone who covered the court as I did could see that he was failing. And yet his death took Washington by surprise, as if it was a bolt from heaven. Only one person was ready. And within an hour of the announcement of Scalia's death, Senator McConnell had made a statement that President Obama would not be permitted to fill the vacancy. Now, here's where chronology becomes interesting to me, because it wasn't at all clear at that point that McConnell could actually carry out this threat. It violated long-established norms of how the Senate and the president related over judicial nominations. And on March the 6th, that is well after McConnell's announcement in February, Senator Orrin Hatch, former chair of the Judiciary Committee, spoke for a number of senators when he said, well, gosh, if the president would nominate Merrick Garland, I think we'd all vote to confirm him. Everybody thinks Garland is great, he's fair and nonpartisan, and I certainly would support him. 10 days later, the president nominated Merrick Garland. But in May, Hatch reneged on his promise and said that he would not support or even meet with the nominee. But what happened? Well, what happened in between those two events is probably the most important single political event of 2016, which I think does not receive quite as much attention as it might. And that is that in early May, candidate Donald Trump released a list of potential nominees to the United States Supreme Court. A list that had been very carefully prepared and vetted by representatives of the Federalist Society and the Heritage Foundation, two very conservative organizations. Every name on that list was of someone considered to be a solid movement conservative. And that list changed the entire course of the 2016 election. These very important constituencies, the religious right, conservative legal movement, had been very suspicious of Trump. I mean, people expected Trump to name Jeanine Pirro to the Supreme Court. And she actually thought he was going to. She went to the White House to make her case. Or his sister, Judge Barry of New Jersey, he thought she was a pretty good judge. That, this guy was a loose cannon. But when he publicly committed that he would only name conservatives approved by the conservative movement, the tenor of the struggle for the nomination and the fall election changed. The religious right swung firmly behind him because control of the Supreme Court and the overturning of Roe versus Wade is the only thing that they care about. Now, the political changes in this were pretty severe. I don't think ever before in history have the names of specific judges been put up during an election campaign for the voters to approve or disapprove. That is a change right there in the nature of the courts, the federal courts in particular. Beyond that, during his, I think October 29th debate with, September 29th, with Hillary Clinton, Trump promised that his judges would automatically overturn Roe versus Wade. I don't think a promise like that had ever been made before, ever. So Trump won the Electoral College. I cannot bring myself to say that he won the election. He won the Electoral College largely on the strength of that promise, largely because powerful groups within the conservative coalition rather cynically backed him on the grounds that they were going to get what they want. And the remaining 4 years were a period of remarkable attacks from the White House on the very idea that courts should be nonpartisan or independent. And just to go over a few of these things, because they passed us by. There was so much going on during the Trump years. You became numb, you became dazed by it. But these things, when you look at them together, are stunning. In June 2016, Trump began attacking specific judges. He wasn't even president, but he demanded that Judge Gonzalo Curiel of California, who was hearing the civil fraud case against the so-called Trump University, recused from the case because he was Mexican and couldn't fairly judge Trump. Trump didn't quite say because I'm white, but that was in the background. Consider the attacks that took place on specific courts and judges after Trump became president. Judge James Robart of the District Court in Western Washington enjoined the first travel ban. Trump called him a so-called judge. When the Ninth Circuit upheld his order, Trump publicly threatened to break up the Ninth Circuit. And we now know, because of a very interesting book that's come out in the last few days called The Divider by Peter Baker and Susan Glasser, two very fine reporters, that in fact he called in the Secretary of Homeland Security. Now, why he thought she would be in charge of this and said, cancel the court and get rid of the fucking judges. And ordered her to draft a statute to do that. You know, she did what a lot of people did, which was not do it, but then Trump fired her. When Judge Garrett Watson enjoined the second track, Judge Watson of the District of Hawaii, Trump called him a political judge. When Judge John Tiger enjoined one of his asylum rules, Trump said this wasn't law, this was an Obama judge. At that point, something happened that had never happened before. And that is, a sitting Chief Justice of the United States rebuked a sitting president. You may recall that in Thanksgiving 2019, the Chief Justice said, we do not have Obama judges or Trump judges. We have judges, independent judges. And Trump, never one to accept a rebuke, responded with 2 tweets in which he put the term independent judiciary in scare quotes to indicate that it was a joke. Meanwhile, Trump then demanded that Justice Sotomayor and Justice Ginsburg recuse herself from all Trump-related cases. There wasn't a whole lot of explanation for that. And finally, and you know, one of the most ominous things was that when Judge Amy Berman Jackson, having presided over a jury trial that convicted Roger Stone of offenses relating to the Mueller investigation, was considering his sentence, she began to receive threats, including one from Stone that put crosshairs next to her face online, and Trump joined in with his tweets attacking her. Some of the judges Trump attacked had to go into hiding. In fact, I've seen it discussed by people who know a great deal about that. One of the explanations for Judge Cannon's bizarre ruling in the search warrant case may be that she was literally afraid of what would happen to her if she did not do what Trump wanted. But let's total up the demographics of what he did as president. 2 Latinos, 1 Native American, 3 Jews. Only one of the judges he attacked by name was not a member of a minority group. That may be a good coincidence. It may not. Finally, that we get to his use of the pardon. And we all know the high-profile pardons late in the game. Flynn, Manafort, Stone himself. What's sort of forgotten now is one that took place in August 2017 when he issued a pardon to Sheriff Joe Arpaio of Maricopa County, Arizona, for contempt of court, criminal contempt of the district court, the District of Arizona. Arpaio had simply defied a district court order that he stop profiling Latinos in his enforcement proceedings. He's just ignored it and refused to respond. Think about what message this sends to judges. Trump doesn't consider defying the courts an offense. And if you cross him, you may be in danger. I don't know that there's any connection between this and what follows. But I think what's remarkable is the degree of deference that the Supreme Court began to show to the Trump administration, most prominently displayed in the case of Trump versus Hawaii, the travel ban case, in which the court noted that Trump had repeatedly said this was a ban on Muslims and the Muslims hate America and so forth, but said, this is a neutral proclamation and we will judge it as such. 5-4. Not content to receive this level of deference, however, the administration prepared to defy the court in the one case that it lost, and that was the census case. again, we're all too, this was taking place at a time when we were overwhelmed by everything that was going on. But we came as close as we have come since 1935 to a situation where an administration simply set aside a Supreme Court order. And the Trump mouthpieces in the media, the Hugh Hewitts and David Rifkins, were out there saying the president could reverse the action by executive order. So you can see that by the time we get to the end of Trump's presidency, judicial independence is a little bit teetering on the edge, especially since Trump repeatedly said that Justice Barrett had to be confirmed because we needed 9 justices to make sure that the Democratic ballots didn't get counted. He said that repeatedly before the election. So now we have this court. It's the last vestige of the Trump administration. It has been trained in deference to conservative values, and it intends to settle some scores. And obviously there's more to be said, and I'm sure that people will want to ask questions about the opinions, but I'm going to stop there because I think your questions are probably more interesting than my ramblings.
Thank you very much. Am I on here? Politics nowadays, that was depressing. But leaders are stalwarts, passionate, and persistent. Yes. Linda is, not Linda, everybody's a Linda here, okay? Terry is picking up cards and will be asking questions. I want quickly before we get those is your compendium, your timeline. When will we see that?
That's for my own use. I work on a very long article for the monthly that will characterize what I came up with. But
so we will see that.
You'll see the results of it, not the timeline.
Okay, well that's fine.
Yeah.
That's enough probably. Okay, we have, as I assumed, we have a lot of questions. To this crisis, how do average Americans respond most effectively?
Well, there's 2 parts of that. If people didn't hear it, it's how do average Americans respond to this crisis most effectively. I think in the short run, the most important thing that can determine the future course of this particular crisis of the court is the election results in November. As we all know, Finley Peter Dunn's famous Mr. Dooley once said, "I don't know whether trade follows the flag, but the Supreme Court follows the election returns." And one of the phenomena we've seen in the ongoing political struggle is that when this authoritarian movement gets away with something, they double down. If in fact the decision in the Dobbs case, the abortion case, proves costly to the Republican Party, this may slow their eagerness to rush other areas. This may abash them, and it may reduce the amount of support they will get from their Republican allies on the Hill. The Republicans are already quite nervous. You can see this. It's in the news commentary. They're quite nervous about going as far as the court said they could go, except for Senator Graham, who just came out and said, we want to ban abortion nationwide. If that doesn't cost them politically, they'll do it, and they'll do more. So that's the short term, right? The long term, I think it's very important. And, I can't tell you exactly how we do this, but we have to stand up and say, what's going on now is not law. The Constitution means something, and it doesn't mean this. And the court can no longer have the aura of sanctity that it once had. When the Dobbs opinion came out, the draft was leaked in May, you may recall, and the court had to surround itself with an unscalable fence, which to me is the symbol of the new court. People said, oh, this is so terrible, you know, this is unthinkable. And my view was, what, right? They're politicians now. We've got a Republican and a Democratic caucus on the court. It's all done by party. Leaks are what partisan bodies have to deal with. Live by it, die by it. And we're going to see more, particularly the protests against that leak were particularly hypocritical to me because the first major leak that I have ever been aware of or covered was in 2012 when the conservative justices leaked that Chief Justice Roberts had changed his vote in the Affordable Care Act case and did so explicitly to punish him. I don't know who leaked the Dobbs opinion, but I do think it's the first of many. I think also to be aware that the justices are nervous. They understand they're out on a limb. We've had these rather pitiful speeches about how the legitimacy of the court must be respected and how we're all friends, we love each other. I've never cared if they were friends or not, right? Who really cares? It's like, oh, okay, I don't have a right to abortion, but Justice Barrett goes to lunch with, I don't care, right? I don't care that they're friends. I don't care that they want me to regard them as legitimate. Somebody asked me to talk about this a year ago, and I said, this screaming about legitimacy reminds me of a scene from The Godfather. All of life can be understood in terms of The Godfather, but in this particular scene, Johnny Fontaine, the singer, has come back to ask The Godfather for a favor. And he says, this big director won't give me the part that I want. I don't know what to do, Godfather. I don't know what to do. And Vito Corleone walks up to him and says, and slaps his face. Says, you can act like a man. I think if they want us to respect them, they can act like a court. And Justice Kagan, bless her heart, said precisely the same thing within the last week. And we can keep pointing out that they're not acting like a court. Is that an easy strategy? No. Is it guaranteed to succeed? No. Is it the only choice we have? I think so.
Okay, you just continue to be depressing.
Would you like me to sing or something? No, that would be
Shouldn't be great, right? Yeah. Sort of three real quick here, or two. What is your opinion on John Roberts' leadership, in quotes? Do you think John Roberts will try to save his reputation? What power does the Chief Justice have to control the court?
Well, you know, I never thought I would actually say this, but I kind of feel for Chief Justice Roberts. If you look at the 6 conservative Republicans on the court, John Roberts is the only one who is actually not a movement conservative, who has not been nurtured and shaped entirely by the Federalist Society and Reaganism and Ed Meese and so forth. Roberts is an institutionalist. He really is seriously trying to do the job that he was appointed to do, which is to run the Supreme Court and keep it out of trouble, because he really values the Supreme Court. Now, that doesn't mean that he's a moderate or anything of the sort. He's one of the most conservative judges who ever sat on the bench, but there are some things he's not willing to do. And, you know, he is very much undergoing an internal rebellion by the other 5 who are all movement conservatives, who are all committed to certain results regardless. And I think you see that play out in the Dobbs case. Roberts, he wanted to approve the Mississippi law. Remember, that was a 15-week ban. And he said in his concurrence, I don't get it. I don't get it why Alito and everyone else is like saying we have to overturn Roe versus Wade. We don't have to. And I think his worst nightmare were the headlines saying court overturns Roe versus Wade. this case asked us, and in their petition for cert, they assured us that this case did not require reversing Roe versus Wade. Now, here's an interesting example of chronology, because the state of Mississippi filed its cert petition in the Dobbs case in May of 2000. And the court repeatedly relisted for consideration, not of 2000, of 2020, repeatedly relisted the case for reconsideration without deciding on the cert petition until spring of 2021. Now, what happened between May 2020 and spring 2021 was the addition of the death of Ginsburg and the addition of Barrett. And at that point, both the lawyers and the 5 conservative justices completely changed their view of the case. So when Mississippi filed its opening brief, it said Roe versus Wade haunts America, it must be reversed. And Roberts is there saying, you know, to say this other thing, and you know, no one was paying any attention to him. So what power does the Chief Justice have? Not much. You know, he has the power to assign opinions. Yeah, he has 1 vote. He has the power to assign opinions, and he has the power to try to convince his fellow conservatives that they're going too far. Right now, from what you hear inside the court, they're not in the mood to listen. They are still angry at him for the Affordable Care Act case. So he is in a difficult situation. And I think for all his blind spots, you know, he sincerely wants the court to act like the court. He's still wrong about everything. But you know, there's a difference between being wrong and being like egregiously wrong. And I think that difference is important here.
Very good. Something that might give us hope. Is the Supreme Court justice impeachable? And if so, how?
The Supreme Court, a justice of the Supreme Court, like any other officer of the United States, that is any other Senate confirmed official, can be removed from office by impeachment. You know, most cabinet officers don't get impeached because they're only in office for a short period of time. I think the last impeachment of a cabinet officer was under President Grant. But justices serve during good behavior. And so under the Constitution, they are amenable to impeachment. Now, it has to be said that during the Jefferson administration, a serious effort was made and an impeachment was brought against Justice Samuel Chase, affectionately known to his fellow justices as Old Bacon Face, very intemperate Federalist who had participated in improper ways in prosecutions of Jeffersonians under the Sedition Act. But that impeachment did not achieve 2/3 conviction in the Senate because a number of senators said they were uncomfortable with the idea of removing a justice because of his opinions. And since then, that's been kind of an unspoken norm. We don't impeach for opinions. There was a movement here in Lane County after Bush versus Gore saying, you know, we need to impeach all 5 of the justices who voted that way. And to which the answer is no, it doesn't work that way, right? Now, on the other hand, let's suppose a justice, something just wildly improper. Let's suppose a justice's spouse were engaged in trying to overthrow the government and lied in official proceedings.
Yeah.
That begins to get us closer to something that's an impeachable offense. And of course, we do have people in the court who could credibly be accused of perjury. I have to say that I think impeachment is not a very promising route to improvement in the performance of the court. I think the proposals for Supreme Court reform are much more worthy of study and much more, all of them are unlikely, but it's possible that Supreme Court reform could happen.
And going to that, would you address the ethics guidelines, norms for the Supreme Court, including conflicts of interest and partisan political behavior?
Sure, here they are. The existing statutes and rules that govern the ethics of federal judges do not apply to judges of the Supreme Court. I think the theory being that they're constitutionally created offices. But if you recall, complaints had been brought against Judge Brett Kavanaugh for his conduct before and during the confirmation hearing. And once he was sworn in, the court dismissed them on the grounds that there was no more jurisdiction over an ethics complaint against a sitting justice. Now, Congress could do something about this. It would set up a very interesting quarrel between the branches, but I think that the better view is on the side that Congress could step in and say, here are certain rules that justices have to follow. Whether they'll do that or not, I don't know. Again, a lot's going to depend on what happens in November.
So as of now, they're their own arbiters.
Yes, completely, yes.
Okay, is there any hope if the Supreme Court would get more justices? Is there any, do you think that's possible?
Is it possible? Sure, it could happen tomorrow. And people tend to act and talk as if 9 justices is some sort of supreme constitutional principle. But if you look back at American history, you can see that the number of judges on the Supreme Court has changed over the years with congressional decision. Right? There's only actually a requirement. I always ask my students this, and they loathe me. But how many justices does the Supreme Court have to have, according to the Constitution? And the answer is 1, because the Chief Justice is named in the set out in the Constitution, given specific duties and so forth. But the other number is, I suppose you could just pick somebody and say you're Chief Justice and you have all the judicial power of the United States. It wouldn't be a good idea, but it could happen. But could we expand the court? Sure. And one of the things that people say to me, I've seen people say this, very smart people whom I respect, is, well, if we do that, if the Democrats were to get enough majority to do that, then when the Republicans came in, they would do that too. Like we'd add 3 judges, then they did 3, then we'd have a Supreme Court of 15, and then more. To which my answer is fabulous. That would be the best possible thing that could happen to this court. Because in that situation, it wouldn't be each individual justice confirmation that was a life and death struggle. There would be enough justices on the court that, we would have some unpredictability. There could not possibly be, a 9-judge Republican majority over an 8-judge Democratic majority. It just couldn't work that way. And if you doubt that, just realize the people that get nominated to the court by either group are highly qualified. All of the people that Trump put on the court are qualified. And there comes a moment when a qualified justice who really did pay attention in law school is not going to swallow what they're asked to do. We saw that this week in the 11th Circuit, where 2 Trump-appointed justices looked at Judge Cannon's opinion and said, what is this, some kind of joke? Appellate judges tend to write in a very polite fashion, but this is pretty direct, the opinion. I commend it to your attention, but they basically say, district court said this, but we have no idea what she was talking about, so we're going to put it aside. That can happen. The idea of rule of law is not dead in this country. It's wounded, but not dead.
There's a fellow out there that's saying something like what you are, and if you believe that it's gonna be partisan anyway,
Yeah,
expand the court and then also term limits.
well, I think term limits would be a great idea. And that arguably can be done by statute. There's been a plan around for at least 25 years that originated with my former dean at Duke Law School, Paul Carrington, in which every president would get a nomination every 2 years. And each nominated and confirmed justice would serve 18 years. That is long enough to be, the most senior justice by the end of it. And then they wouldn't be removed from the bench. They would still be justices of the Supreme Court, but they would be senior justices, just the way we had. I'm sorry, what?
Emeritus.
Or demeritus, as when my designation as emeritus came up in front of the fact that there was some discussion of that latter level, luckily I avoided it. But he was senior justice, and what they would do would be to sit when there were conflicts of interest that made one of the 9 young, less junior justices not able to sit. So you'd always have a 9-justice court. They would receive their salaries, they would have chambers at the Supreme Court, participate in various events. They just wouldn't be active justices. So arguably you can do that without amending the Constitution. And I think it would do 2 things. One is, when the Supreme Court was created, life tenure, if that's the term, life wasn't quite so long. Right? I mean, some justices did live a long time, but many did not, right? And to have this court that was dominated by septuagenarians and octogenarians for 11 years, that would have just been startling to the framers of the Constitution. So, they put in good behavior, and I think they just left it at that. But I do think that we should do something. And I think term limits would be fine. I mean, people say, oh, we can't have term limits because then the justices will be worried about their next job and that will influence their decisions. Like, really? You think if you go around and you say, well, oh, let's see if you're qualified for this. So, 18 years, justice of the Supreme Court. How's that work out for you? You'll find work and you would have a federal pension, and it's just ridiculous. There is no reason why people can't serve a fixed term and then leave office. And it's much better than the idea of impeachment or anything like that would introduce this kind of political stochasticism into the system that would make it less stable than it is now.
Okay, thank you.
Yeah.
I win an argument on that one, so I appreciate your answer. Neither. The little-known legal theory that's about to come before the Supreme Court is an argument used by the former occupants' legal team during the effort to overturn the 2020 presidential election. On 1A, Diane Reeves' interior, Jen White explains what it is and why critics fear that it could upend the way federal elections are run and certified.
And the question is? So
There's
far,
no question.
there's no question. Well, that's true. I mean, I can talk a little bit about the so-called independent legislature theory. And I try to explain it to people the following way. My sainted Uncle George Epps, dead now, he's 55 years, served on a lifetime basis as the dealer and major domo of the poker game at the Richmond Elks Lodge. Every night he could be found there. And he was a beloved figure. And usually in the Elks, from what I was told, I never actually qualified for Elkdom. But there was a lot of discussion about how terrible President Truman was and all this civil rights nonsense. We got to put an end to this and so forth. In 1948, Senator Byrd tried to get the legislature to remove Truman from the ballot so that he couldn't get Virginia's electors. That plan failed, but I thought to myself, what if George and his buddies had decided we are the state legislature and we're excluding Truman from the ballot. And write it down on a piece of paper, George, and hand it out. It's the law. Well, I think we all know what would happen, right? Somebody would go down to circuit court, you know, and say to Judge Henning, look, these crazy guys up at the Elks are claiming that the state legislature is set out in the state constitution. They can't be, please issue an order, you know, appropriate order stopping all this nonsense about awarding our electors. And he would have done it because the jurisdictional statutes and the Virginia Constitution gave him the power to say, no, that's not the state legislature. Well, the independent legislature theory, if you apply it as it's stated, would say, oh no, the state court couldn't do anything about it. And George could send his friends, his 11 friends as the electors. And if the regular state wanted to send electors, then Congress could decide what were the correct electors. But, you know, only the Supreme Court or Congress, state courts could have nothing to do with that decision. That's the independent legislature theory. Because the Constitution in Article 2 says that each state shall select in a manner directed by the legislature thereof, so-and-so electors for the president. What the independent legislature theory says is that because that word is used, legislature, state courts and governors and secretaries of state cannot interfere in the conduct and counting and decision of presidential elections, regardless of what's in their state constitution or statutes. Now, if you look around the country, and I don't have these figures in my head, but I did do it, and it's quite a significant number of states, including swing states like Pennsylvania, that have state constitutions that say there is a right to vote, and it's guaranteed much more broadly than it is in the federal constitution. And so as a result, there have been decisions over the past 50 years broadening the right to vote, removing barriers to the right to vote under state constitutional law, not federal law. Under the independent legislature theory, the legislature would be free to ignore all of those. And for example, in Pennsylvania, when the state Supreme Court struck down some restrictions on receipt of ballots, the legislature could ignore that. For the Secretary of State interpreted the statute empowering that office to make it easy for people to vote by doing certain things. The legislature could reverse those. The legislature could cancel the election. The legislature could simply wait until after the election, and if it came out the wrong way, do what Trump was asking them to do in 2020 and award the state's electors to their favorite candidate. And nothing in this, only the Supreme Court would have any jurisdiction to consider that. Now, for a court that says that it's all about original understanding, the original understanding of the independent legislature theory, I think, is an attempt to scan the mind of Bill Rehnquist and Ed Meese. The theory did not exist until Rehnquist was on the court in a case called Anderson versus Celebrezzi, in a dissent. He said, well, this is what I think. It pops up again in 2000 and is propounded to the Florida legislature, which was preparing to set aside the results of the popular vote in Florida and award Florida's electors to Bush if the recount had favored Gore. And interestingly enough, the idea was brought before the legislature by a panel of scholars, including two names that should be familiar even to non-legal scholars, one being Professor John Yoo, who later wrote the torture memos, empowering the US intelligence community to torture terrorism detainees, and the other was named John C. Eastman. That's where this theory comes from. It is so extreme and so crazy that, you know, it's almost, you don't even know how to refute it. But one thing that's clear to me, and I think if you know anything about the framing and ratification of the Constitution, is that if the states, the people in the states who are considering ratifying the Constitution, had been told this provision will take all control of elections out of the hands of the people and the courts and the Constitution of your state, and give it to the legislature and the Supreme Court. I don't think that was the original understanding. I simply just don't think it is. And the two reasons are, first of all, I don't see any evidence of it. Nobody's produced any contemporaneous statements that I've seen. And secondly, is what my students call WTF. I mean, no, what are you thinking? What are you smoking? What a stupid idea, right? But there is a fairly powerful 2 or 3 justice caucus on the court that wants to do this and have this in place by 2024. And I think we know what will happen if that happens. So it's something to keep an eye on.
Well, we're coming close to the end of our time. Thank you all for reading questions here. But do you have any encouragement for individuals or particularly the league?
Well, I think we have to understand that we have gotten through 2 crises like this before. There was a lot of damage, but one thing that's really important is, that citizens should not be fooled. We may have to obey orders of the court, but we don't have to pretend that they make any sense. And I went back, getting ready, hoping to leave people with something happy, and looked at President Lincoln's first inaugural address, because of course, the Dred Scott opinion had a great deal to do with making Lincoln president and the crisis in front of the country, which was fueled by the court's attempt to lock slavery in nationwide. And he said, I do not forget the position assumed by some that constitutional questions are to be decided by the Supreme Court. Nor do I deny that such decisions must be binding in any case upon the parties to a suit as to the object of that suit. But while they are entitled to very high respect and consideration in all parallel cases of the government, nonetheless, the candid citizen must confess that if the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the instant they are made in ordinary litigation between parties and personal actions, the people will have ceased to be their own rulers. And I think Lincoln put that into effect in the sense, he did tear up the habeas corpus, but that's a minor thing. But, the idea being, look, okay, that's the decision on that issue. But that doesn't mean I have to act like, or the executive branch has to act like, that's the value of the Constitution. And I think one of the things that disappointed me about President Biden was that it took him so long to come up with any sort of executive response to the Dobbs case. I would like to have seen that the day after, doing things that were still permitted, but doing them and saying, as another branch of government, we interpret the Constitution differently, and we will pursue our interpretation as we can within the limits of legality. Because it's very important to realize that the Supreme Court's decisions are not the only interpretation of the Constitution. And if we lose sight of that, we're in a world of hurt. So that is as hopeful as I get.
Thanks.
Thank you.
Thank you. Yeah, it's my fault too. Come to our next event. You saw it on the flyer on your table, and watch for other media, our Facebook, our Argus, she said, of the editor of the artist, read it. And we also do Facebook, some live Facebook, so you can see really immediate current stuff coming up, not maybe as much as a month old. And again, thank you. So honored to have been here. So goodbye, y'all. Stay safe. Yes?
What's this?
I don't know. Donate. Yeah, forever. And besides money, we need some labor. We can make sure it's something you're interested in and doesn't last forever. You don't have to take to your grave. Okay? Thank you so much for showing up.
Chuck, it's good to see you. That's right.